Hello and welcome to another Bentley David Tutors video. Today we are going over how to get away with mail fraud, which partly includes the legal studies course. So we're going to go over a few really interesting topics today. We're going to look at some basic legal concepts such as the rule of law. Jeremy knows exactly what I'm saying because I'm reading off a script.
I hope you're not.
No, I'm not reading off a script. No, Dan said I no need to worry. So we'll go over some basic legal concepts. We'll look at the rule of law, for example. We'll look at the court hierarchy as well.
Yep.
It's a really fun topic.
That's a good bit.
What else will we look at?
We're going to look at some things like the reasons for laws. We're going to look at the difference between customs rules and laws. We're going to look a bit later on how a bill or a law is passed through government. We're going to look at statute versus common law.
Yep, so Jeremy, you don't need to say everything because there's going to be bookmarks at the bottom of the video.
It'll be
bookmarks. Luckily, so you guys can just all skip over whenever Jeremy's talking to another part where I'm speaking.
Yeah.
Or you could skip to the part that you actually want to hear about. Just a quick shout out to Dan Cito. Thank you for your lovely comments on the last video. Unfortunately, we couldn't get matching drink bottles, but we do have an axis of symmetry, so hopefully everything's looking quite lined up. We appreciated that you liked the laptops, the iPads. Yeah, that's courtesy of Apple, who are our sponsors for today's video. Apple at your local farmer market.
Yeah, farmers market. Yeah,
correct.
I think they're in season at the moment as well.
They
so
are.
That's good.
So yeah, if you like the video, which you have to, if you like the video, leave a like, subscribe, share it with all your friends.
Yeah.
If you've been able to purchase them after looking at our economics video, which you all should have watched, even if you don't do economics, because it was of such high quality.
Well, it's got the life advice as well.
That's
even if you don't do the subject, it's more about the common experience that you have.
That's
with
exactly
economics
right.
as well. Yeah.
But I guess we'll stop talking. And
No, we won't. No, we'll keep talking.
Probably will keep
Sadly
talking.
for you, but we will keep talking.
Or not if I'm speaking. Everyone loves the sound of my
true.
voice, but I guess if Jeremy gets us underway, we can get the worst over and done with.
Okay, so we're going to go through lots of NESA syllabus dot points here, which may or may not be covered in some sort of legal studies exam that you may sit at some point.
They wouldn't be. They normally steer very far away from
the
NESA
NESA
syllabus
dot points, yeah. But okay, so we're going to start with the dot point to define law and the meaning of law. So law, the actual definition, is a rule imposed on all members of a certain community, which are officially recognisable and enforceable by an enforcement agency. An example of that would be the police. So in terms of our reasons for laws, we have things like safety, maintaining order, protection of economic interests or intellectual property, providing a framework for punishment, and also providing equality of treatment amongst citizens.
Thank you for that, Jeremy. So now we'll move on to distinguishing between customs, rules, and laws, and values and ethics.
Those are separate, so we'll be distinguishing between values and ethics at the end.
Thank you very much. All right, just going to speed through some definitions. Customs, collective habits or traditions that have developed in a society over a long period of time. So classic example, the one that I would use because it's easy to remember, is wearing a white wedding dress when getting married. It's an easy one.
Will you be wearing a white wedding dress?
I will be wearing a white
well?
wedding dress.
Excellent.
Next we've got rules. Rules are regulations or rules and regulations are principles governing procedures or controlling conduct. So for example, these would be like school rules. So things like, I don't know, not chewing gum or wearing the school uniform would be a school rule. But in most cases,
Not wearing the school uniform is a school rule, is it?
Yeah, that's right.
Okay, good.
But in most cases, you're probably not going to be prosecuted by the police for chewing gum in school.
Yeah.
And then finally, we've got laws, and laws are similar to what Jeremy's defined. The formal rules of society that have been agreed upon by the majority of members of a group, which govern their behaviours and activities. And also look at the relationships between organisations and individuals.
And so therefore we see that the difference between customs, rules and laws are their spread and their severity. So customs are expectations which are developed over time. They only cover a smaller group of a community and are not enforceable. However, rules have a wider spread over a whole group and that group is often bigger than the ones that are covered by customs. And they also govern the conduct of group members, and they may also be somewhat more serious than a custom could be in terms of punishment. And then finally, we have laws, most commonly cover the whole community or whole society within a country. And we see that these cover individual behaviour and activities, and also relationships within people, between people within a society, and are usually officially recognised and enforceable.
So now on to the second part of that dot point, which is values versus ethics.
Yes.
So values are principles, standards, or qualities that are considered to be worthwhile or desirable within a society. So values are sort of things such as kindness or equality and like words similar to those. I think you should get the gist. Compared to ethics, which are rules or standards directing the behaviour of a person or members of a profession that are considered morally right or wrong. So that it's right to commit mail fraud. It's wrong in all circumstances to commit mail fraud. It's a federal crime.
And so therefore we see that the difference between values and ethics is that values refers to the principles or standards that an individual or group consider to be desirable, whereas ethics refers to the standards which direct individual behaviour based on a moral grounding for each of them. So the next thing that we're going to look at is to describe the characteristics of just laws and the nature of justice. So a just law is a law which allows all people to receive fair treatment and outcomes and ensures that human rights are recognised and respected. Further, we see that some characteristics of just laws is that they include that the laws must be accepted, enforced and discoverable. They cannot be applied retrospectively and should be based on equality.
So, quick cheeky definition of justice. Justice is the legal principle of upholding all generally accepted rights and enforcing all expected responsibilities within a group, whilst also ensuring
Equality of outcomes.
Whilst also ensuring equality of outcomes for those involved. So justice has three parts. We've got equality, fairness, and access. Do you want to take us away with
I'd love to. So equality, what do we mean by equality in these three parts of justice? So this means that all people governed by laws are treated equally under these laws. This ties into the rule of law, which we'll get into later, and suggests that no person should receive any unfair advantage or disadvantage based on things like age, gender, financial status, and other things like that.
So we've got fairness next. So fairness is pretty similar to equality, but refers to fairness of a law or punishment. So I guess the best way to differentiate is through an example. So for example, it's not fair and therefore not just to make a fine for jaywalking $30,000. And it's also not fair to make dancing illegal unless Jeremy's dancing, and that should definitely be illegal. Crime. So therefore, fairness refers to the creation of laws and punishments which are fair on the people they govern and are proportional to an offence.
Yeah, and finally we have access, which is pretty much one of the simplest ones to think about. Those other two can get a little bit murky between them. But access just refers to the principle that all people governed by a legal system and by laws specifically should have equal access to that legal system. So this means that all laws must be physically accessible. So there must be somewhere where I can go and look at all the laws. Otherwise I could be breaking a law which I don't even know is a law. And we also see that all people must have equal access to the legal system. So laws must be written in a way that when people can find them, they can actually understand them. And people should have access to the system generally. So this is why if people can't afford, say, a lawyer, we provide one for them, because it would not be fair to only give proper legal defences to people who can afford it.
So now we'll move on to the next dot point, which is defining and investigating procedural fairness and the rule of law.
We're going to define and investigate.
Yeah.
Okay. Got to get my magnifying glass. It's a good one.
It's going to take a second just
write that
to
down.
let everyone
We'll just wait till they're all done laughing. Then they can focus back on it. Okay.
Alright, so we'll start
back
with
here.
procedural fairness.
Sure.
So procedural fairness refers to the concept that there must be fairness in the processes that refers to the concept that there must be fairness in the processes that dissolve.
Dissolve disputes.
So procedural fairness refers to the concept that
Procedural fairness refers to the...
So procedural fairness essentially refers to the concept that there must be fairness in the processes that resolve disputes. So for example, laws need to be fair, but the procedures, such as the trials and the trial process, must be fair as well. And this has three main parts. So an individual has the right to know the case against them. So they need to know what they've been charged with. They need to know what evidence there is that's allowing them to be charged with that crime.
Of course.
Secondly, they have to have an unbiased decision. So whether that's a decision by jury or by a judge alone or a magistrate in a lower court. We'll go into that a bit later.
Absolutely.
And thirdly, they must have a decision based on relevant evidence. So we couldn't convict Jeremy for a crime just because we don't like him.
Yeah. Although that would be good.
I wish we could. I wish we could.
So what we see is procedural fairness is closely linked to the concept of natural justice, which stipulates that everybody should be treated fairly in any legal situation and has two main principles. Firstly, the right to be heard, which includes the right to a fair hearing, which is basically point 1 and 3 about knowing the case against you and having a decision based on relevant evidence. And secondly is the right to have a decision made by an unbiased decision maker, which is essentially point 2.
So now we'll move on to the rule of law, which is quite an important concept because it sort of applies to the rest of the legal syllabus.
Absolutely.
So definition. The rule of law is the concept that no one is above the law except myself, and that everyone is equal before the law, including those who make the law. Therefore, the legal system has a series of checks and balances to ensure power is exercised according to the law. We'll get to those lovely things later.
Some checks and balances.
Some divisions of power, separations of power.
But the rule of law just tells us basically that nobody is better than the law, and everybody must be equally, except for Luke, everybody must be equally answerable to the law. So this includes concepts like the presumption of innocence, the lack of the availability of retrospective laws, the fact that government agencies have to behave as model litigants. We also see that the separation of powers between the legislature, executive and judiciary, and also that the law and its administration must be subject to open and free criticism.
So now we'll look at defining and providing features of anarchy and tyranny.
Yeah.
So they're pretty much just the opposite of each other, as most of the definitions that we've gone through, believe it or not. So anarchy is the absence of laws and governments within a state, and it refers to a state of complete lawlessness and chaos within a community, which can occur due to a lack of laws or lack of fair laws, a lack of an enforcing body, so lack of police, and it can also occur in a change of government or a lack of government due to whatever reason. So unfortunately, I've had a rude interruption from, I'm not even going to use that names.
Yeah.
That's how disappointed in naming her. But yeah, we'll wrap up anarchy there. But also some key characteristics of anarchy are like widespread violence, looting, and a great example is the Capitol Hill riots.
Yeah, of course, absolutely. Now, our next point here is tyranny, which, as Luke said, is basically the opposite of anarchy in terms of what causes it, but they are quite similar almost in terms of the sort of characteristics that we see. So tyranny refers to rule by a single leader who is holding absolute power in a state, like Luke over Belly David shooters. So tyranny refers to the opposite of anarchy, which is when total rule and harsh laws are enforced. The tyrant is a single leader who has unlimited power over the people within a state, and tyrannical powers often inflict harsh punishments for even minor offences and do not feature checks and balances on power. So these are key characteristics of tyranny. With tyranny, power is taken away from the people by the leader, rather than a traditional democratic system where the leader is given power by the people, like we see in a democracy. Yeah.
So now, onto some sources of contemporary Australian law. So
contemporary, is that the dance that you do?
That is contemporary lyrical, ballet, hip hop.
Wow.
In fact, it'd be easier to list the ones I don't do.
That you don't do, absolutely. Okay, right. So sources of Australian common law, or is that
right.
like tomato barbecue and stuff?
Australian contemporary law.
Contemporary law. Getting ahead of myself with common law there.
Common law, that is too advanced.
Okay. So we're going to start with the first dot point here, which is where we're going to outline the origin of common law. We're going to then also look at equity, precedent, the inquisitorial system of trial, and the adversarial system of trial, and that is all of the things there. So
can you remind me what common law is?
I can remind you what common law is. So common law is law made by the judges or by the courts through precedent, and we're going to explain some of those words a little bit later. An example of this is in the Gutnick v. Dow Jones 2011 case, which established defamation in the online realm for any jurisdiction.
Great case. You can also use Marbo versus Queensland,
Yep.
1992, in the High Court of Australia. It's something classic.
Yeah. Okay. So next thing is we're going to look at what equity is. So equity, the system of equity acted as a check or a balance on the common law system back in olden day England. So the equity system referred to the system in which cases were judged on their own merits, not based on the decision of other judges. So this allowed for any issues in the common law system and common law decisions to essentially be resolved.
So by like old England, you mean like 1980? Like
Yeah,
old time.
really old. Yeah. Like before we were born. And
It was 11th century, wasn't it?
I think travelling judges started in the 11th century.
Yeah.
So yeah,
Something like
which
that.
we'll go into in a minute.
So now we'll look at the development of common law and how it came about, which is similar to what I just sort of talked about then.
Yes.
So it started with the idea of travelling judges, established by Henry II. These judges travelled around the country and dealt with matters that the people of a town felt to be unfair, and these travelling judges had the power to overrule local sheriffs and make sure that the law of Henry was upheld and that the people felt like their right to appeal was upheld. It was that really the first opportunity for people to appeal a decision made by authority.
Yeah. So this developed into common law as all judgments made by a judge would be given to all of the other judges to keep it consistent and allow for other decisions to be referenced. One judge decided to compile a book of all of these judgments, which then became the English common law.
However, common law as it is today was also developed through the equity system as well. So to allow for decisions in common law courts to be resolved, British established the Court of Chancery, led by a priest and a judge called the Chancellor, who looked at cases on their own merits and could correct common law decisions, and they operated on a moral and religious principle basis.
And in 1870, the British Parliament decided to combine both of these courts, the Court of Common Law and the Court of Equity, which allowed judges to make decisions based on common law and equity law.
So now we'll move on to the inquisitorial versus adversarial court system. It's a really interesting topic, actually.
It is.
So firstly, we've got the inquisitorial system, which is a system in which the court or part of it, so the judge normally, is actively involved in conducting the trial and the investigation.
Keep going.
Okay, I'll go ahead. The judge determines which witnesses are called and what questions are asked, and they seek to determine the truth themselves. The judges are not impartial and there are not parties acting on behalf of both sides. The judge instead determines the truth themselves. And this system is used in many countries in the European Union. So the other system we have is the adversarial system, which is the system we use here in Australia. It's the system that they use in the US, so in most of the TV shows, this is what you'll have seen.
Like The Bill?
Like The Bill, one of my favourite legal TV shows. So in this system, the two sides will present their version of the facts of a case to an independent judge who will listen impartially to the facts presented and make a judgment based on the facts presented. So in this system, parties or adversaries represent either side, and the process is dependent on the aptitude of these parties operating for either side. So these parties are often like a lawyer or a barrister representing their client in court. So further, the judge purely acts as an adjudicator over the trial and is not at all an investigative body and cannot go out themselves to seek out evidence. Uncalled for.
Yeah, was. But as you can see in those amazing diagrams up there, we've got adversarial system of trial over there, inquisitorial system of trial over there.
Is that symmetrical?
Well, it is, because we've got them on either side of the axis of symmetry. So therefore it must be. So Dan, we've done this for you, so please be thankful. Final thing that we're going to look at in here is precedent, which has quite a few little points under it, but I think I'm going to say them all because I'm sick of listening to Luke. So,
no one else is though.
No, nobody else is, but that's okay. So precedent is a principle or rule established by a judge in a previous legal case which must be followed by lower courts. So when can a precedent be made? Firstly, if there is no other laws that covers the case at hand. This is not very common nowadays because of the amount of precedents that there's been. Almost all areas of crime have some sort of existing law or precedent already there. Secondly, they can create a precedent if the precedent produces a clarification or interpretation to a law which is already in place in the state or the country. So this is much more common, as considering there are so many laws, there are many clarifications which will have to be made. So the next thing that we'll look at is parts of a precedent. There are two parts. This is quite a niche bit of knowledge, but quite important. So firstly, this is a bit of Latin, so shout out to our Latin students. We've got ratio or ratio decidendi or decidendi, or however, well, not that you'd say it if it was Latin, I guess, but this is the legal reason for the decision made that is presented by the judge, and it's essentially their reasons for producing the precedent. And then we also have the obiter dicta, which is any other remarks made by the judge, and this does not make up part of the precedent.
I think we should expand to making Latin videos.
Maybe we'll make Latin videos.
But we wouldn't say anything.
Yeah, maybe we'll just produce some Latin transcripts.
Yeah.
So the next thing is following of a precedent. So generally, the lower court, a lower court must always follow precedents of a higher court unless, firstly, the facts of the case in the precedent are slightly different to the facts in the case they're looking at.
Wait, so they don't have to follow the precedent if it does not apply to their case?
So they don't.
That is crazy.
They don't have to. Secondly, if the decision has been reversed, for example, if you are in the lower court and the district court has established a precedent, if the case from the district court is then appealed to the Supreme Court and the Supreme Court overrules the decision of the district court, then that means that that decision is gone and the precedent is gone as well, so the lower court does not have to follow it. And finally, if the precedent is from a local or equal level court, you don't have to follow it. Now finally, we have the slightly more complex thing, which is where there are two types of precedent. We've got binding precedent, which is where the lower courts are bound to follow the decisions by higher courts, no matter the judge's opinion on the precedent or on the decision of the higher court. And then we have persuasive precedent. So this is where superior courts don't have to follow the decisions of the courts below them, but they can choose to do so to help them make their decision. And this also extends to decisions made in other common law countries, where judges can use them as persuasive precedent if they think it suits the case well and is a good idea.
Thank you for that. Not really thank you, but
yeah, but
well, not getting through it.
Thank you.
So now we'll move on to the court hierarchy. The hierarchy of set
This is
federal
no
courts.
fun. This bit's no fun.
I guess I'll be nicer and I'll let us take turns.
Oh, thank you, Luke.
But we'll start in New South Wales with the local court. So I think in each section we've got the 3 sections for each court. We've got original jurisdiction, which refers to what can that court hear, what can it make decisions over. Then we've got appellate jurisdiction, which is the appeals that court can hear. And then we've got court information, which I guess is just some general information about those courts. So we'll start with the local court and its original jurisdiction. So the local court has the jurisdiction to deal with summary offences and conducts criminal proceedings to determine whether or not indictable offences are to be heard in the higher court. So summary offences mean they're quite minor crimes, so they might be like possession of a drug, traffic offences,
murder,
mail fraud.
Mail fraud is very serious.
Very serious court. So a committal hearing is an inquiry held in the local court to determine whether there is enough evidence against the defendant to warrant a trial in a higher court.
Interesting.
The local court also has the jurisdiction over civil cases with a monetary value of up to $100,000.
Yeah.
The local court has no appellate jurisdiction, so it cannot hear any appeals as it's the lowest level of court, so who's appealing to the local court? And some other general information, local courts are presided over by a magistrate, not a judge, and there can never be a jury because it only hears summary offences. And the local court is also responsible for bail hearings.
Oh, do you know that from experience?
I do.
Excellent. Next court, Coroner's Court. Right, so the Coroner's Court is a specialist court in New South Wales at the local level, so this is at the bottom level in line with the local court, which deals with the cause and manner of a person's death, and also with fires and explosions, apparently. And so the powers of the Coroner's Court are set out in the Coroners Act of 2009. So the role of the coroner is to determine the identity of the deceased and establish the cause of death, which will then inform the coroner's court. To go to the coroner's court, the deaths would normally need to be suspicious because of reasons such as an especially violent or unnatural manner of death, sudden death with no clear cause, after an accident up to 1 year, which may have caused the death, if the death was in police custody or prison, or the death was while receiving medical care or medical treatment and within 24 hours of receiving an anaesthetic. So the appellate jurisdiction for the coroner's court doesn't really apply because, again, it's on that lowest level of court, so you can't appeal to it. However, it can be recommended that the coroner investigates based on the reasons that I've just mentioned. And finally, on some court information, in some cases, a coronial inquest can be held in the coroner's court, in which witnesses will give evidence and expert witnesses, like people who are experienced in the area of, say, DNA technology or death, like Luke, would give expert testimony to try and establish the cause of death or other facts of the case. If the court finds that criminal activity has occurred, the court can recommend that charges be laid, but cannot lay those charges themselves.
Next, we have the Children's Court, which is also equally at the bottom of the hierarchy. So the Children's Court's original jurisdiction is that it deals with matters related to the care and protection of children and young families, and it also deals with criminal justice matters which involve children and people who are under the age of 18 or who were under the age of 18 at the time of an alleged offence. And the Children's Court cannot hear civil matters. That'd be quite interesting, actually, as a child in a civil case. Again, there's no appellate jurisdiction because there's no courts below it again, but the cases have to fit the above requirements for it to be heard in that court. And some other general information, the court was established under the Children's Court Act of 1987. It is a closed court, meaning that it's not open to public viewing. The court is overseen by a magistrate who has specific training in dealing with young people, and there is no jury. Bit of extra knowledge while Jeremy's doing some drawing. Based off my little research project last year, the Children's Court can hear children from as young as 10 years old, because
Is that the minimum age of criminal responsibility?
that is the minimum age of criminal responsibility, and that's when children are deemed to have be legally aware that they've committed a crime and they're legally aware that what they've done is wrong. So potentially you could have a kid in jail at the age of 10.
I'm gonna make sure that's in the frame. Yeah, good.
Good working, Jeremy. You know what? Let's move on to the drug court. The drug court's original jurisdiction is that it is a specialised court in New South Wales which deals with matters in which criminals are dependent on drugs or alcohol. So the court can hear referrals from the district court or the local court. However, specific eligibility requirements apply. Yeah, so this one isn't really on the hierarchy, it's sort of just off to the side. And that's because it's a sentencing court, not a court that hears the actual matter itself and determines guilt. So to be eligible for the drug court, a person must be highly likely to be sentenced to full-time imprisonment if convicted, have indicated that they will plead guilty, be dependent on the use of prohibited drugs, be over the age of 18 and willing to participate, and they must be referred from a local or district court. A person is not eligible if they've been charged with an offence involving violent conduct, they've been charged with a sexual offence, or they're suffering from a mental condition which could prevent participation. In terms of appellate jurisdiction, the drug court is still considered to be at the lowest level. So again, it does not hear appeals. Instead, similar to the coroner's court, it can get referrals to the local or district court, which is slightly different. And the drug court was established under the Drug Court Act 1989 in New South Wales and seeks to address the underlying drug dependency, which results in criminal offending. Is Jeremy back, or will I go into district courts?
Jeremy's back to the district court. To the district court. Right. District court. Right. Original jurisdiction of the district court is now A level up. So like me compared to Luke. Right. So the original jurisdiction is that it hears serious criminal offences, particularly indictable offences, such as drug offences, manslaughter, armed robbery, serious sexual offences, but not murder or treason. Those are examples of something that's heard by a later course. And they also hear civil cases involving debt recovery, personal injury claims, and other civil cases dealing with sums of money not exceeding $750,000. The appellate jurisdiction here is that it can hear appeals from the local court and from the children's court because they're on that level below. And some court information is that all states except for Tasmania have a district court, and the New South Wales District Court is established under the District Court Act 1973 in New South Wales. The court hears the most serious criminal cases which come before the courts in New South Wales, and trials are heard before a judge and 12 jurors, although the defendant can choose to have it heard just by a judge. Civil cases may also be heard in front of a jury of 4 people to determine damages, but this is less common.
Next we have the Supreme Court, which is another step above. And the Supreme Court hears the most serious civil cases involving cases where monetary claims exceed $750,000, and they hear the most serious criminal cases such as murder, treason, and piracy, or mail fraud. I don't actually think they hear mail fraud, which is a shame. So the Supreme Court deals with the civil issues of contract and negligence cases. They hear matters of equity. They hear probate matters such as wills. They hear admiralty matters, which are matters involving ships and boats. And they hear commercial matters such as building disputes. In terms of its appellate jurisdiction, the Supreme Court can hear appeals from the District Court. And in terms of court information, each state has its own Supreme Court, which is presided over by a Chief Justice. The New South Wales Supreme Court began in 1823 and operates under the Supreme Court Act 1970. The Supreme Court also uses a judge and a jury, and in some cases can hear federal cases if given some federal jurisdiction. Jurisdiction's actually Latin as well, isn't it?
Jurisdiction? Wouldn't know. I don't look at Latin. Alright, we're now going with the Court of Criminal Appeal and the Court of Appeal. So in terms of the original jurisdiction here, the Court of Criminal Appeal and the Court of Appeal, which we're just going to refer to as one court, has no original jurisdiction, which has been interesting. I know,
No.
It cannot hear any cases just originally.
Wow.
However, it has significant appellate jurisdiction. So the court only hears appeals and usually hears them from the Supreme Court or a district court. Anyone found guilty in the Supreme Court or the district court can appeal and have their case be heard here. There are 3 main grounds for appeal accepted. Firstly, if it's a challenge involving a question of the law. Secondly, matters involving a question of fact. And finally, appeals on the grounds of an undue punishment, or too severe, or potentially it's not severe enough. You could appeal that your punishment is not severe enough. It is possible to appeal further from this court to the High Court, but these applicants, as we'll talk about a bit later, need special approval from the High Court to do this. In terms of some court information, the court is the highest court in the state for dealing with criminal matters, and trials are heard by 3 judges, but up to 5 may sit for particularly important proceedings. There are no juries here.
Now we've got the Land and Environment Court, so it has the original jurisdiction to hear cases, it has specialist jurisdiction over enforcing and interpreting environmental law within New South Wales. It also has wide jurisdiction to do with matters such as zoning, environmental planning, environmental offences such as pollution as well. The Land and Environment Court has the appellate jurisdiction to hear some appeals of local government rulings, and it's... Gee, that's harsh from Jeremy. He said that it's a very irrelevant court. No jury but decides on environmental stuff. I don't think the people who work very hard in the Land and Environmental Court would be too happy to hear that.
Yeah, continue on to the next one.
I'll go on to the next one. So now we'll move on to the federal courts. Firstly, with the federal court. So the federal court has the original jurisdiction to, firstly, hear matters such as administrative law, so things such as taxation, admiralty, which is Jeremy's favourite because it has boats, intellectual property, native title, bankruptcy, other things like that. The court also has the power to review some federal government decisions in areas such as social security, but the cases heard are only based on legislation that has been made. It doesn't look at any criminal cases, as there's no criminal division, but looks at things such as things at a legislative case, such as Novak Djokovic's case when he tried to come in for the Australian Open. The federal court has the appellate jurisdiction to... It doesn't have the appellate jurisdiction to do anything because it's essentially the lowest level of federal court, so no federal cases can be appealed to it. And then in terms of court information, there's no criminal branch for the court, and it can sit anywhere in Australia where necessary. The court can hear appeals from some lower courts, such as the state Supreme Court, which is really interesting because you just read that there's no appellate jurisdiction.
There's not much appellate jurisdiction, but it may be able to hear some cases from the state Supreme Court.
I didn't write these notes. Jeremy thought mine were good notes.
Well, I hope there's no notes that you're reading from. You should know this. Anyway, Family Court and Federal Circuit Court. So, this is 2 courts that were merged together, I think, in 2021. But it sort of makes a lot more sense to just look at them separately. So we'll look at the family branch first. This deals with applications for divorce, spousal maintenance, property and financial disputes, parenting orders, and other things like that. The court's main role is to look after the needs of children, whether in a marriage or not, and to deal with more complex family law disputes. So the circuit court is the other part. Now, the circuit court deals with matters of family law as well, which is slightly odd, migration and general federal law matters, including things like reviewing decisions made under the Migration Act of 1958, administrative law, admiralty again, human rights, consumer law, industrial claims, and jurisdiction on these matters is shared with the federal courts and sometimes with some of the state courts. In terms of the appellate jurisdiction, it's pretty easy here. It can hear appeals from the lower courts, and the courts travel around Australia and are also in fixed locations in the capital cities.
Wonderful.
We're now to the last one. Oh, okay.
So now we've got the least important court at the bottom of the hierarchy, which is the High Court. The High Court's original jurisdiction involves matters involving the Constitution or a constitution. The High Court has the original jurisdiction to hear matters involving the Constitution or where it's needed to interpret the Constitution. So it also hears matters arising under any laws made by the Commonwealth Government. It hears matters of admiralty, I've just learned it's pronounced. It hears any legal challenges as a result of Commonwealth elections. And it also hears disputes that are had between state governments. Jeremy's got in bold here that the only court allowed to deal with constitutional matters is the High Court. The High Court has the appellate jurisdiction to hear any matter that has been appealed to the High Court by lower courts if they're granted special leave, which is about to come later.
Sorry, just in guys, Pat Cummins has confirmed a debutant for the second test in Karachi.
Swepson, I'm guessing.
Mitchell Swepson has been confirmed to debut in second test.
I heard good things. However, these appeals are often seen by 3 or more judges, and in order for them to come from the Court of Criminal Appeal, they need that special leave, which I talked about before. So special leave is essentially when a case or matter has been deemed important enough that it needs national importance, and it gets special leave to leave the Supreme Court and head to the High Court. So an example of this is the famous "The Dingo Ate My Baby" case of Lindsay Chamberlain, RV Chamberlain, 1982, I believe it was.
Correct, yes.
Just off the top of my head.
Well done.
And this case was deemed so nationally important that it got special leave from the Supreme Court to be heard and appealed in the High Court. This court's general information is that it's the highest court in Australia and was formed as a result of federation in 1901. It has ultimate jurisdiction as the highest court in the country and usually sits in Canberra. The court consists of 1 Chief Justice and 6 Justices who are appointed by the Governor-General on the advice of Cabinet, and the court's role is to interpret the law and provide a coherent body of common law for the whole country.
Okay, next we're going to outline the role and structure of Parliament and the legislative process. Okay, so firstly...
You're going to talk about statute law.
I am. It's under this. Okay, so we spoke about common law before. The other way to make law called statute law. Statute law refers to the law made by Parliament. Thus, the role of Parliament is to debate and introduce statute law to effectively govern the nation. Or ineffectively. They don't have to do it effectively as well. So in terms of our structure of Parliament, we have the fact that the Parliament is bicameral, meaning that it has 2 houses, which allows for reviews and checks and balances to be put in place. The lower house, called the House of Representatives in the Federal Parliament, and the Legislative Assembly in the New South Wales State Government, and its role is to introduce bills into Parliament, debate them, and then vote on them, potentially to pass on to the upper house. And it's made of representatives of each electorate around the country, which makes it based on population. We then have the upper house, called the Senate, federally, and the Legislative Council at a state level. Its role is to check over and scrutinise the work of the lower house and their bills, and then they vote, they debate, amend, and vote on the bills again, and then pass them on or throw them out. Then we have the Governor-General, or the GG, as I like to call him at the federal level, and then just the Governor at the state level, so just the G. So the G or the GG is the Queen's representative in either the state or the nation, and their role is to receive bills that have passed through Parliament and give them royal assent, which would pass them into law. Now, this is a largely symbolic role, which means that bills that go to the Governor-General that have passed through Parliament are almost always, I'd say, well, but they are always given royal assent and passed through. It's largely a symbolic rule these days. But finally, in terms of just how bills go through Parliament, so a bill refers to a piece of legislation that is being debated but is not yet in law. So it's put into the lower house, it's still being debated, it's not yet law, which is why it has bill at the end. And then we have an act which has received royal assent and is now law, and hence the bill gets dropped from the end and is replaced with act.
So now we'll move into delegated legislation and its function. So delegated legislation refers to laws made by authorities other than Parliament. So these authorities are delegated this power by an act of Parliament. Delegated legislation involves less important legislation that Parliament has no time to draft, debate, and vote on, and is handled by subordinate bodies such as government departments or local councils. So there's 4 types of delegated legislations. We have regulations, which are laws made by the Governor-General, Governor or Executive Council. We have ordinances, which are laws made for Australian territories, such as Norfolk Island. Then we have rules, which is legislation made for government departments, and bylaws, which are laws made by local councils, which are governed by that council.
Like when bin day is.
That shouldn't be delegated.
That should not be delegated. That should be the Parliament, really.
So some analysis of delegated legislation. I'll do advantages, you can do some disadvantages.
Fabulous.
I love sharing. So some advantages. So firstly, the people making the legislation are usually experts in the field. Like you wouldn't have Jeremy making laws on anything. Secondly, the delegation of minor legislation frees up parliamentary time for more serious issues. And thirdly, it's easy to change delegated legislation, and therefore it's more flexible.
Yeah. Some disadvantages, though, is that members of Parliament do not have time or expertise to fully check this delegated legislation. And with many different bodies involved in making the delegated legislation, there can be some inconsistencies that arise. Finally, there is very little public scrutiny and publicity surrounding the delegated legislation, and thus the public cannot really voice their views on this legislation.
So now we'll move on to probably the most important topics that
Yes, we're going to look at
the division and separation of powers. We're going to start with the division of powers.
Absolutely.
So definitely have a keen listen on these ones because they can sound quite similar,
but they're different.
But they're actually quite different. So welcome back. We had a slight change of scenery, keeping up with the theme. Keeping up with the theme of our economics video, where we like to change it around. You guys guessing.
Yeah.
But I believe we are up to the division of powers. Again, I don't know if we're going to cut it out what I said before, but this is probably one of the 2. Division of powers and separation of powers are probably the most important topics that we're going to go over in the video. So pay attention.
Please.
We know you are paying attention.
You obviously are.
Continue paying attention. So the division of powers divides powers of lawmaking between the state and federal governments, and this provides a check on the balance of both state and federal governments and ensures power is not too centralized. It also means that no one government has the power to make laws or control the activities over any locality in the country because it's split between all three. How are they divided? Well, they're divided in the Constitution. So first we've got Section 51.
Yes.
Which lists every area in which the federal government can make laws. However, the state government can make laws on a lot of these things too. So therefore, Section 51 details concurrent powers, which are the powers that both federal and state governments hold at the same time.
Section 52 details the areas of law in which only the Commonwealth government can legislate on. So that means only federal government can do this, state cannot control any of this. This includes areas such as trade and commerce with other countries, foreign relations, national defence, immigration, and some other things
Marriage.
like that. Yes, marriage. And as the federal government are the only people who can legislate on these areas, they're called exclusive powers, in which the states have no power over them and the federal government have exclusive legislative rights. Now, the final thing that we look at is residual powers. So residual powers are the areas of legislation which are not given to the Commonwealth government in any way, whether exclusive or concurrent, and they are not referred to in the Constitution at all, and thus the states get them. This includes things like public transport, education, hospitals, and public housing. So just to explain how that works there, we've got exclusive powers. So I'll start from the top. Section 51 details all powers that the Constitution cannot. You know what? I'm going to do a Venn diagram. I'm going to set up a Venn diagram. So we've got state. We got state and feds. Right here, we have exclusive powers. This is in Section 52, am I correct?
Exclusive powers.
Yep, set out in Section 52.
That is correct.
Excellent. Right, exclusive powers set out in Section 52 of the Constitution. Then residual powers. Not set out anywhere in the Constitution. They're specifically not laid out anywhere, which is why they go to the states. In here, concurrent powers. This is going to be some maths, guys. Concurrent powers is the powers set out in Section 52, Section 51 minus the powers set out in 52. So, 51 minus 52. So why that is 51, all powers that feds can do.
Do you have a pillow?
Do I have a pillow so you can go to sleep? All powers for feds, plus some that the states can do, and then 52 shows the exclusive powers. So let's say I have like marriage, and if we had then taxation there as well. Right, so this is obviously not all of them, but Section 51 would set out all of these, which means that the federal government can talk about any of these. 52 speaks about these. 52 says that marriage and defence are only for the federal government, which means that then if we're looking at concurrent powers, this bit in the middle is 51 minus the 52, boom, boom. So therefore taxation is a concurrent power. So that means both federal and state governments can legislate on it. So,
You done?
I'm done. Thank you. Is that the recall video? Wow.
So there's also two other sections of the Constitution that are quite important in knowing about the division of powers. Section 109, which pretty much says that when the state and Commonwealth governments make laws on the same area which are conflicting, the Commonwealth law prevails and the state law is invalid. Our amazing example of this is the Marriage Equality Act 2013 in the ACT, where the Australian Capital Territory government attempted to legalise same-sex marriage in 2013. However, this was challenged and overturned by the Commonwealth in the High Court because at the time, same-sex marriage was still not legalised in Australia under federal law, and because marriage is an exclusive power, the law was challenged and overturned.
Absolutely.
The second important section, section 128, which outlines the mode of altering the constitution. It pretty much just says that in order to do this, it needs to go to a referendum. But the interesting part of a referendum is that you need to achieve a double majority for it to pass. So firstly, it needs a majority yes vote of all Australians, and secondly, it needs at least 4 out of the 6 states to have a majority yes vote, and doesn't include territories. Territories
don't count. Don't count. Right. So that is division of powers. On the contrary, we got a different thing: separation of powers. Don't get them confused.
Don't get it confused.
Right.
So separation is separation. You just struggle with that back in like year 5.
I have written that there.
I know. I'm just.
Oh, okay. So sorry, Luke just explained that he can't spell. Right. Division of power.
No, I can spell, just not very well.
Sorry. Division of powers, how power is split between the state and federal government to stop centralisation. Separation of powers, different. Right, so the separation of powers refers to how power is separated between the 3 key organs of government, which I guess is heart, liver, kidney.
That's correct.
Okay, right. So this provides significant checks and balances on power, where each arm or organ acts as a check on each other. So our 3 organs here are the legislature. These are the lawmakers, the people in parliament, and they have the power to make laws and vote on them as well.
That's like the bills and acts thing we were talking about before.
Absolutely. The next thing we have is the executive. These are the people who administer the laws made by parliament. There can be some overlap between the executive and the legislature, and the executive features some ministers from the cabinet, like the health minister, as well as government agencies which administer the laws. Finally, we have the judiciary, who is probably the most important check. They are the courts which interpret and apply the law.
So the most important check of power is between the judiciary and the legislature, as no member of the legislature can overlap with a member of the judiciary. And then there is the most fairness here. Judges in the courts can check the power of the legislature in 2 ways. Firstly, they can create precedent in terms of the interpretation of the law and constitution to change how it is applied, or secondly, they can hear cases from citizens on legislation and deem its validity, meaning they can overrule some laws. It's like jury nullification.
Yeah, that's correct.
Equally,
the parliament can...
Equally, the parliament can check the power of the legislature. The parliament can implement new legislation which invalidates the precedent or interpretation of the judge, although this cannot be applied retrospectively, because we know that the nature of just laws
needs no retrospective laws.
And the parliament also appoints high court judges and can remove judges if found to have committed serious misconduct.
Have you ever been removed from something for serious misconduct?
Not on my record.
Okay. So there are some protections on the separation of the judiciary here. So the legislature cannot change the pay of judges while holding their positions, nor can they remove judges easily. Judges also must be completely separate to the legislature. That just stops all that little corruption stuff that Luke likes to advocate for. So therefore we see that the division of powers refers to how the legislative powers are divided between the state government and the federal legislative bodies to prevent the centralisation of power, whereas the separation of powers explains how legal powers are split between the legislature, judiciary and executive to provide checks and balances on each independent arm of government and to prevent a dictatorship. Not that that's necessarily bad.
Not always.
Yeah.
So now we'll describe the role of the High Court in the interpretation of the Constitution. So a bit of this will overlap, so I guess we'll just sort of skim over it.
Yes.
High Court has the total power for interpreting the Constitution, and this makes up the majority of its original jurisdiction, and they have complete control over this, making it an exclusive power, brackets sorta, according to Jeremy, for the High Court. And these powers of original High Court jurisdiction are outlined in section 75 and 76 of the Constitution.
When a constitutional matter comes before the court, 7 justices hear the matter and decide it. The High Court's interpretation of the Constitution involves making determinations about about what areas the Commonwealth can legislate on and what areas should belong to the states. The High Court also makes decisions on the powers of each level of court, as well as making decisions on any limits to that power.
So section 73 of the Constitution outlines the appellate jurisdiction for the High Court, and it presents that the High Court can make, hear and determine judgments, any federal court exercising federal jurisdiction and any state Supreme Court.
Section 73 also states that all judgments made by the High Court as the highest court in the land are final and conclusive. Any appealed case must be granted special leave, as we mentioned before, which is where the High Court grants approval for a case to be held in its appellate jurisdiction to actually be held in the High Court. And most appeals to the High Court are made on the basis of a question of law, which is a disputed legal contention that is left for the judge to decide, or a matter that is so significant, like the one that Luke mentioned before, that it warrants High Court attention, or a dispute between multiple courts. Right, the final dot point that we're going to do today is to
Made
examine the characteristics of Aboriginal and Torres Strait Islander customary law. So customary law refers to the principles and procedures that have developed through general usage according to the customs of a people or nation and are treated as obligatory. So there are a number of key features of Indigenous customary law, which we will detail below.
That's right. So we'll start with the diversity of the Indigenous societies. So there are many different Indigenous groups. They all have different versions of customary laws, and thus some laws differ from group to group. However, overall, the similarities outweigh the differences in customary law. And I'm sure most of you would have seen the pretty cool map where it shows all the different Indigenous groups throughout Australia. And that just shows how many different groups there are and how it's quite understandable that there wouldn't always be this consistent customary law. So a clear example of this is that many different Aboriginal and Torres Strait Islander groups feel that mediation and dispute resolution should involve the whole community, and this is a key feature across all groups. So many laws like prohibition of insulting elders are equally common across the groups.
Yeah. So the next thing is the spiritual nature of customary law. So the dreaming is the basis for many components of Indigenous customary law. And considering secrecy covers many aspects of customary law and oral tradition is far more important than written tradition in Indigenous cultures, it is hard to document exact sets of customary law like you would with Australian contemporary law. Many of the laws which have originated from the dreaming relate to the treatment of the land and those who live on it. And since colonisation, many Aboriginal and Torres Strait Islander people have been living under both contemporary Australian law and customary law. However, many Indigenous people may choose to use customary law to settle disputes as a far more culturally inclusive and potentially beneficial system for dispute resolution than Australian contemporary law.
So now ritual and oral tradition. So customary law is a critical part of everyday life, the values, customs and ethics of First Nations people. Most laws relate to marriage, childbearing, religion, family and kinship. And these laws have been passed down through oral traditions. So different community members get to know different laws, so they only really need to know the laws that apply to them. So for example, some laws that are specific to girls will be passed on to girls at a young age. These laws are often passed through religious ceremonies, which are often considered sacred laws and are passed down again through oral traditions, such as stories or songs and things like that.
So the next thing is dispute resolution. So when laws are broken, customary laws are broken in Indigenous communities, the family of both parties, in many cases, as well as the whole community, are just involved in dispute resolution. So discussions and meetings are held in place of a standard judicial process, which we might see in Australian contemporary law, and the meetings are often held during ceremonial periods of the year. Elders may meet with those involved to see if they can resolve the dispute like that, and what we see is maintenance of relationships and community generally are critical priorities for Indigenous people. These relationships allow for information to continue to be passed down through communities through traditional means, and thus to maintain these relationships in Indigenous communities, mediation is critical, which we see as potentially a far more beneficial way through mediation to resolve disputes in order to maintain a relationship than just things like putting people in jail.
So finally, we've got enforcement and sanctions. So there is an expectation that all community members follow the customary law, as with Australian contemporary law. So order is maintained through self-regulation or consensus among family heads. And elders play a critical role in guiding these decisions and may intervene if they see it to be necessary. The offences can either be examples of breaches of sacred law or offences against property or persons. And when a law is broken, elders are directly involved in handing out the sanctions. So the elders and the victim's family may be involved in determining punishment through mediation, and some punishments include public humiliation and ridicule, or in the more serious cases, spearing and death. The justification for some punishments, like beatings, is to restore balance between the parties and their families.
Yeah, which again goes back to that idea of maintaining relationships, which we spoke about before. But that wonderfully, I'm sure for you, certainly for us, brings us to the end of today's video. For those of you who do business studies as well, we're about to double back and film that business video. So even more fun for us and for you. But yeah, sorry, that was very threatening. Something just, it's loud noise.
Haters.
Yeah, it's haters. It's the haters coming for us. But we hope you enjoyed today's video. Like always, if you did enjoy, leave a like. Also go and check us out on TikTok at Bentley David Tutors. Right. We posted two new TikToks.
They were pretty famous.
They went very viral. One of them is at 730 views. But we did think they were quite funny. So if you want to go and have a look at them, we do think they're quite decent. And hopefully we'll post a few more soon.
You can also check us out on Instagram. We had a few messages after our economics video, which were quite entertaining.
Yes,
and if you ever have a question or anything like that, we might answer if we don't hate you as a person.
Yeah, that's true. So yeah, also you can leave any questions in the comments down below. Have a discussion. Dan Cito, please. We'd love to hear from you in the comments and your feedback on this video.
Maybe comment Care Bear if you care.
If you care, comment Care Bear. Okay. But yeah, thank you for watching, and we will see you all in the next video, which might be business studies.
Maybe not.
Okay, bye.